Good morning, everyone, and welcome back to our weekly webinar series. We are expecting a very, very interactive session today, and we are dealing with a very, very important topic. Over to Anil, sir.
Thank you, Ankit. Last week, first of all, let me welcome all of you in 129th episode of AAA Weekly Webinar Series. Last week, in 128th episode, we were getting, in fact, too many questions regarding the matters of insolvency resolution process of personal guarantors. And some of the questions were also on the bankruptcy. So therefore, we decided that we will look into all these questions and we will frame our own questions and answers based on all the input received. But before we go ahead, we also would like to discuss recent judgments on the matters of personal guarantors. So starting with the personal guarantors matters, I would say after some time, then we will again go back to the question answer session. And I would request all of you to prepare your questions, because today we will spend more than 50% of our time to question and answer sessions. First, we will try to answer the questions that has been asked from us. Then we will take the questions from all of you. So a couple of Supreme Court judgments or a couple of important NCLAT judgments that we would start with, so that we actually built a platform for the questions. So the Supreme Court, in fact, held in the case of Dilip B. Jeevarajka versus Union of India on 9th of November 2023. It was actually a bunch of 384 petitions. And in fact, what was held in this particular judgment, that the RP acts more as a facilitator, gathering information and recommending whether to accept or reject the insolvency application. That is his duties under Section 99 report. The role is recommendatory rather than adjudicatory, lacking the power to take over the assets or make binding decisions. So where the RP is appointed under Section 97, that appointment is just a facilitator, information gathering, and recommending whether to accept or not. When Section 100 order comes, that would be a separate power and separate role. Now, the interim moratorium, this was also held in this judgment, Dilip Jeevarajka judgment by Supreme Court, that the Section 96 says that it initiates automatically on filing of an application under Section 94 or 95, the moratorium initiates. It says that it stays all the legal proceedings concerning the debt, but without affecting the assets of the debtor. Without affecting the assets of the debtor means that the lenders cannot recover, but the debtor can sell the property owned by him. That he can sell, he can alienate, and he can even transfer the title. Then it is totally different from Section 14 moratorium. So this was the judgment, which are in fact very, very important judgment. And it actually says that the court held that the natural justice principles are observed at the stage of adjudication under Section 100, when the adjudicating authority admits or rejects the application. The constitutional validity of Section 95 to Section 100, that means Section 95, 96, 97, 98, 99 report, and even the order, this was upheld as constitutional. The court even found that no violation of Article 14, right to equality, and Article 21, right to life and personal liberty, was in fact violated. The court therefore dismissed all the applications, so therefore the insolvency started going on. Another judgment which is very recent, on 20th of August 2024, our principal bench of NCLAT gave a judgment in the case of Paresh Parekh versus Alchemist Asset Reconstruction Company Limited. It was given by Justice Ashok Bhushan, And the main issue which was discussed in this particular matter, that when the personal guarantee was given, there was a put option with the lenders, and there is another company called Agnes Capital LLP. That put option could have been exercised before even acting against the personal guarantors and invoking the guarantee and initiating the insolvency process. So this agreement provided that in the event of default by the corporate debtor, the RBL Bank could exercise the put option, obligating Agnes Capital LLP to purchase the pledged securities and cover the outstanding amount owed by the corporate debtor. So this was not opted by the lenders, but immediately the insolvency was started. Now, what actually is held in it's basically the issue involved was that whether the invocation of deed of guarantee was valid due to the failure of the financial creditor to exhaust remedies under the put option agreement. So finally, it was held by the NCLAT that the invocation of guarantee, the deed of guarantee, was deemed to be an independent and distinct contract, and the liability of the personal guarantor was not contingent on the exercise of the put option agreement. Therefore, the invocation of the guarantee by the financial creditor was valid. Second argument that was also rejected, that the assignment agreement between RBL and Alchemist Asset Reconstruction Company was valid under Section 5 of the SURFACI Act, and the personal guarantors had no locus to challenge the assignment. In this case, particularly, even the personal guarantor challenged the assignment agreement also. Finally, the natural justice NCLAT held that no violation of the principle of natural justice have been found. The appellants were given an opportunity to file written submissions after technical issues during the virtual hearing, and NCLT was justified in proceeding based on the written submissions due to the time-sensitive nature of the IBC. Now, the another judgment, which is a recent judgment dated 18th of July 2024, it is again from the our own principal bench, NCLAT, from Justice Ashok Bhushan, and it is the name of the judgment is KM Sebastian versus State Bank of India. So in this particular case, there are three issues which are involved. One, that whether a fresh notice invoking the guarantee was required before filing the application under Section 95. This is very important. Whether a fresh notice, because in this particular case, the notice was issued only in 2014. No further notice was issued invoking the personal guarantee, but no notice was issued and the insolvency started. Whether the second argument was whether the application was barred by limitation, and since it was filed with the initial notice of 2014. Now, in this case, even Section 18 of the Limitation Act 1963 was also applied to assess whether the limitation period had been extended or not. Now, in this case, NCLAT held that the argument that a fresh notice was required before filing the application under Section 95, it was not found to be a correct argument. The court found that the initial notice given in 2014 was sufficient to invoke the guarantee and initiate proceedings. Now, on the limitation, the appellate tribunal held that the one-time settlement proposal which was made by the corporate debtor in 2016 and 2017, as well as the decree passed by DRT, Debt Recovery Tribunal, in 2019, extended the limitation period under Section 18 of the Limitation Act. So therefore, the application was not found as barred by limitation, and the adjudicating authority's order initiating the insolvency process was upheld. Now, in another important case, which is Dheeraj Vadhavan versus Union of India, again, this is from Appellate Tribunal. principal bench from Justice Rakesh Kumar Jain and Justice and the technical member Naresh Salecha and Indrajit Pandey. So in this case, the Diwan Housing Finance Corporation Limited (DHFL) in fact extended loans, and the corporate guarantee was given. And in this case, the defense that was being taken by Dheeraj Vadaman, whether a single financial creditor, that is Union Bank of India, can file an insolvency application under Section 95 of the IBC without the participation or consent of other members of the creditor consortium. Whether the application under Section 95 of the IBC is maintainable, these are the questions. And finally, the NCLAT held that even the clause 43 of the deed of guarantee and clause 8.5 of the security trustee agreement were also referred by the appellant to argue that the application should have been filed collectively by all the consortium members, because in the deed of guarantee or in the security trustee agreement, there may be a clause that collective action would be taken. However, the NCLAT, the appellate tribunal, held that Section 95 of the IBC does not require all financial creditors to file the application collectively. A single creditor such as Union Bank of India is allowed to file an application on its own without needing the consent of the entire consortium. The court rejected the applicant's reliance on the Rakshit Dheerajlal Doshi case, stating that the facts are different. So in this case, the consortium members supported the Union Bank of India's action, and there was no interstate dispute amongst themselves. Therefore, the application was maintainable. So this was also a very important judgment. And we actually see another judgment of 2nd August 2024 from NCLAT Principal Bench, Justice Ashok Bhushan. It is Julekha Amir Dhodia versus Bank of Baroda. And in this case, the main issues which are involved is whether the CIRP of the corporate debtor was already completed and her offer for one-time settlement was not considered. And earlier rejection orders, like this particular case was earlier rejected and again it was recalled. And then it was being challenged. It was being challenged because this is the recall order, whether the recall order can be done or not. Now, in this case, the legal issues which was involved, whether the personal guarantor could challenge the recall of the rejection order and the subsequent admission of Section 95 application in the same appeal, whether the OTS, one-time settlement proposal offered by the guarantor, could have been considered by the financial creditor despite the ongoing insolvency process of the principal borrower. Now, in this case, the court held the challenge to recall order. In fact, the court ruled that the Julekha Amir Dhodia could not challenge the recall order dated 16th of February 24. In the present appeal, as she had already participated into the subsequent hearing. So at that time, before the adjudicating authority, she did not challenge the recall order, and rather she participated into the subsequent hearing. Now she is challenging that, but that is not the time to challenge that recall order. The recall order was distinct from the admission order, and both should have been challenged separately as per Section 61 of the IBC. So she could not have challenged both in one single appeal. However, the OTS appeal, the court observed that the resolution plan for the corporate debtor had already been approved by the Committee of Creditor and is pending for the final approval of the NCLT. Since the corporate debtor's CIRP was nearly concluded, the bank had the right to reject the OTS offer. Again, the court held that the admission of Section 95 application against the personal guarantor and directed that all aspects, including financial contribution made during the CIRP of the corporate debtor, be considered while finalizing the resolution plan for the personal guarantor, because in this particular case, the personal guarantor also contributed for the CIRP cost. Now, coming to the another case, which is again from the principal bench, Justice Ashok Bhushan, Arvind Dam versus State Bank of India. This is dated 16th of April 2024. And in this case, the major issues were whether the interim moratorium under Section 96 bars subsequent applications by other creditors for insolvency proceedings under Section 95. Then second issue was the jurisdiction of NCLT New Delhi to entertain the Section 95 applications filed by SBI given the ongoing insolvency proceedings against Castex Technologies and Stride Auto Parts. Now, in this case, the NCLT decided that interim moratorium under Section 96 does not prevent other creditors from filing independent Section 9 applications. However, only one application will be admitted. And once the application is admitted, then all the creditors will file their claim. However, by just saying that 96 is invoked, therefore, the banks cannot file their independent applications under Section 95 is not correct. The NCLAT held that even if there is one application already filed by the promoter under Section 94, then there is a second application which is filed by another creditor, then still there is a possibility of third or fourth application that can be filed. However, any application which is accepted first, and then all the other application will become infructuous, and then all the creditors will file their claim with that resolution professional who is appointed in the first order. Then the multiple applications can be possible. Then is the NCLAT held that NCLT New Delhi, there is no error in the jurisdiction because the State Bank of India, the Section 95 application was, in fact, it is having the jurisdiction of NCLT New Delhi only. Now, in this case, the jurisdiction argument raised by Mr. Dam also was rejected as NCLT had the authority to hear Section 95 applications based on the provisions of Section 60 of the IBC, which requires all proceedings against the corporate debtor and its personal guarantor to be heard by the same authority. In fact, Supreme Court on 10th of July 2024 have also dismissed the appeal from Arvind Dam, and therefore all these things which was decided in this case by NCLAT has actually found the finality from the Supreme Court. So we have another judgment from NCLAT Principal Bench, again Honorable Justice Ashok Bhushan. It is dated 7th of February 2024, and it says, in fact, in this particular case, the personal guarantor could not file the reply on time, and there was a delay of 6 days, and the adjudicating authority imposes a cost of 2.5 lakhs on that personal guarantor. Now, even the appeal before the NCLAT was that this is too high, and also it was only a delay of 6 days. NCLAT, in fact, noted the delay in filing the response, and they found that this 2.5 lakh cost is too high. So the NCLAT, in fact, reduced the cost from 2.5 lakh to 25,000 rupees only, and it was directed that they will deposit within 10 days the revised cost, and then the adjudicating authority was also directed to accept their response, accept their reply, and then adjudicate the matter. NCLAT Chennai bench held in the case of Mahendra Kumar Agarwal versus PTC India Financial Services Limited, and in this case, the main issue was involved that the NCLT does not have jurisdiction to handle cases related to personal guarantors like him. He was arguing that no insolvency proceedings are pending, no liquidation proceedings are pending for the corporate debtor to which the personal guarantor has stood as personal guarantor. And he says that as per the jurisdiction, as per the section 179 of the IBC, the jurisdiction of all these people who do not have any pendency of the cases of their of their companies to which they have given they have granted the corporate loan. There is nothing like pending. So he was saying that this application should have gone to DRT rather than NCLT. Now, in this case, since there was no pending issues, then in fact the appellate tribunal held that Section 60 of the IBC provides jurisdiction to NCLT for personal guarantor cases when the insolvency proceedings of the corporate debtor are also before NCLAT. This interpretation is supported by Supreme Court's ruling in Lalit Kumar Jain versus Union of India. So even in Section 179, the appellate tribunal says that it is subject to Section 60. While DLT may handle other individuals' insolvency cases, personal guarantor of corporate debtor fall under NCLT jurisdiction, and that is something which is important. The tribunal therefore held that it is possible to go ahead with the NCLT jurisdiction instead of DRT jurisdiction. Another important judgment that I have with me is the Ashok by Morakhia versus Reliance Asset Reconstruction Company Limited. This judgment is 13th May 2024, again from Justice Ashok Bhushan. And in this case, the key issue involved was that the application under Section 95, in fact, was filed through a resolution professional. RP acts on behalf of the creditor, and this process is compliant with the law. The objection was that how the RP can file an application. The tribunal found no defect in the Section 95 application, which had been duly signed by the RP. So the application was also not time barred, and because even the Supreme Court's suo motu writ petition, which actually excluded from all limitations 15th March 2020 to 28th of February 2022, that period was in fact removed from the limitation calculations. Another judgment from NCLAT Principal Bench, Justice Yogesh Khanna, is in the name of India Bulls Asset Reconstruction Company Limited versus Pawan Kapoor. In this case, the Pawan Kapoor is the personal guarantor, and the application, in fact, filed by India Bull was rejected by the adjudicating authority, and it was rejected by so what happened is in fact, India Bull sold the property. India Bull sold the property of Pawan Kapoor, and the property was sold after Section 96 moratorium. So, but the court held that the appellant's argument was that the symbolic possession of the property was taken in 2019 and the physical possession was completed in January 21. Prior to the insolvency proceedings, they had a vested right to dispose of the property. This was said by India Bulls. The applicant contended that the moratorium under Section 96 of the IBC should not apply. Then the respondent and the tribunal argued that Section 96 stays all legal actions. Finally, the NCLAT held that the interim moratorium under Section 96 of the IBC applies to all debts of the personal guarantor, including the mortgage property. Therefore, the appellant could not proceed with the actions under Section SARFAESI after the moratorium is commenced. Therefore, the tribunal also cited the relevant judgments, including Sanjay Dhingra versus IDBI Bank Limited, which confirmed that Section 96 applies to security interests created by the personal guarantors. Therefore, the India Bull appeal against the order of adjudicating authority was dismissed by NCLAT. So this Sanjay Dhingra judgment, in fact, not from anywhere else. It is from High Court of Delhi. It is in the name of Sanjay Dhingra versus IDBI Bank Limited, where it was held that the moratorium under Section 96 is very effective, and this moratorium actually no lender can actually take action against the assets of the debtor. So this is the Ankit we have in brief, and I would first see what kind of questions are coming in, and then we will move on to our own questions in case we can see some of the questions as of now. Questions only on insolvency of personal guarantors.
So question number one is from Hari Prasad ji. He says, can the date of OTS proposal by the CD be treated as acknowledgement of debt to extend the limitation period with respect to the PG case?
Yes, because this the debt is basically debt is taken by the corporate debtor. And if the debt is acknowledged by corporate debtor, that means there is a debt and the limitation period gets extended. And there are judgments that we've just spoken in the last 30 minutes.
Then Lalit Maheshwari ji is asking that when there is approval of resolution plan by COC and subsequently by AA, when PG gives guarantee on the original loan taken by CD on approval of resolution plan, there is material variance in the contract of guarantee without consent of the PG. Will it not be contravention of section 133 of the Contract Act? So, in case a resolution plan is being processed for the CD and the personal guarantee is not something that is impacted in any way, that remains as a liability of the personal guarantor, but the liability might reduce to the extent of money which is realized by the creditors from the resolution plan. That's about it.
In fact, Ankit, the Supreme Court has very clearly held in the case of Lalit Kumar Jain versus Union of India, and that judgment was dated 21st May 2021. It was very clear that just approval of the resolution plan by the COC and the adjudicating authority, any kind of a contract amendment or modification without the consent of the guarantor would not impact on the obligation and liability of the guarantor. So the lenders will still have all their rights to proceed against the guarantor, even if a resolution plan is approved, even if the section 138 of the Contract Act, the modification has actually been done without the consent, but that has been held by Lalit Kumar Jain versus Supreme Court of India on 21st May 2021.
Then we have a question from Mr. Atul Tandon. He says that in a case, the CRP commenced 2 years ago and still in process. Now, the FC has filed applications under Section 95 against the PG in which the claim amount has been calculated up to the date of notice to the PG. Is the FC right in enhancing the claim against the PG as compared to the claim in the CD? Absolutely, I don't see a problem here. Because when he files the claim against the PG, it will be the claim, the latest claim. So it will not stop.
Now, the one is the invocation of personal guarantee. That is the date of claiming something from the personal guarantee. Without invocation of the guarantee, without sending a demand notice, the insolvency of the personal guarantor cannot be started. So therefore, one important part is the invocation of the personal guarantee. So whatever amount is mentioned in the invocation of personal guarantee plus interest up to the date of filing the application or filing the claim is correct.
And that would ideally be the latest amount, right? Like the
Yes.
question here that, okay, the amount is changing from the amount that was filed before the in the CRP process. So that's not a problem because that is bound to increase. That is bound to increase because of the interest element that will kick in post the CRP's initial initiation date.
However, any amount received during the CIRP process from the corporate debtor that will reduce the claim of the creditor against the
personal guarantor. Arun Kumar ji is asking that if personal guarantor gives repayment plan covering repayment over a period of 5 years, whether it can be forwarded favorably to NCLT. If the bank say that, okay, we are okay with the 5-year plan. If the creditors are okay with a 5-year plan, that's okay. I don't see there is a bar with respect to period, right?
So there is no bar on the period. Also, at this stage, in case this 5-year period is also contingent on any of the business of the personal guarantor, out of that business, the personal guarantor is proposing to pay this amount, then creditors have a right to appoint another RP for monitoring the 5-year period, for monitoring the income that is being proposed in the 5 years, out of which the personal guarantor will pay. That option the creditors have. However, 5 years or 10 years is not a limit. There is no limit of repayment plan.
Vikram Bhatnagar is asking a very interesting question. He says, can financial creditor assign their debt after moratorium has been imposed on property of PG to CD? So basically, yes, there is nothing that disallows the assignment of debt by a creditor. So rather, IBC provides for it. It has specific provisions that if assignment happens during the CRP period or during the personal PIRP process, then this will be the process for the creditors to replace their name in the list of creditors. So it is perfectly allowed and perfectly okay.
Assignment is allowed. Yes, Ankit. Very right.
Whether personal guarantor liability will exist where the CD is sold as a going concern in liquidation and his liability is allowed to be totally extinguished under relief and concession. So the this is coming in from Mr. Vintus Sunganj, and he I think here the answer is very clear, sir, that the personal guarantee liability is not waived in normal circumstances unless and until when the liquidation is being done for the CD as a going concern, then the personal guarantor rights of a bank or creditors are also getting transferred. Other than that, there is no scenario where personal guarantor liability will cease to exist. It will continue to exist for that part of the liability that is still not realized by the creditors.
So I think the different question is slightly because the proposal is to sell the company as a going concern in the
In
liquidation.
liquidation.
Now, the technical answer that I would like to add what Ankit said, in the liquidation of a company, first of all, the liquidation estate would be built by the liquidator. So in that liquidation estate, the any kind of recoveries from the corporate, any kind of recovery from the personal guarantors also becomes part of the liquidation estate. Now, it all depends what kind of legal document is prepared, because the entire liquidation estate can also be sold to anyone. It all depends on what is included in the company as a going concern, how it has been agreed by the stakeholders. But in case it is specifically agreed by the stakeholders, yes, it can be done, because it is possible to say that the banks have also taken a kind of a very alerted call that they are selling along with this company as a going concern all their rights to proceed against the personal guarantors or even the corporate guarantors. That is technically possible, but it all depends upon the stakeholders whether they agree or not specifically. In case they don't agree specifically, then the lenders will have their right to proceed against the personal guarantors and the corporate guarantors.
Then Mr. Kedari Narsimha. So the creditor is moving Section 7 application against the CD as the Section 95 petition already filed against the PG is getting delayed. Any precaution to be taken by the RP, proposed RP in this background? So where 95 application is already filed and is getting so the simple, I think the simple idea in both these cases for an RP to look into is that what are the with respect to fee, because we have discussed in previously also that Section 7 petition or Section 97 95 petition, the RP should always understand, although CRP safeguards the RP with respect to his fees, Section 95 petition may not have safeguarded the RP. Then the second part is what are the kind of assets that are available for sale. That's it. Nothing else, perhaps.
Yes,
If you have
Ankit,
anything.
the RP is being proposed for the company, for the corporate,
Yeah.
and the personal insolvency of the director is already started. Now, see, like the personal insolvency is separate and the CIRP is separate. So I don't think there is any kind of precaution which is required by the proposed RP, and both are doing their separate jobs. Every creditor is filing their claims before the RP of the PG and RP of the corporate debtor. They would be filing their claims up to the date of commencement of insolvency in both cases. The claims can be different because the dates are different. They both can actually verify the claim, collate the claim based on the facts that they have. However, if there is anything which is recovered either out of the personal insolvency or out of the CIRP, the other party, the other RP will ask for modification in the claims. I don't think there is
So
any.
to add to this question and to add to this discussion, like one of the things that have recently happened is that for a company for which I myself am appointed as an RP, the promoters also got into, or they have the personal insolvency is already started for them. So I got an email where the RP who was appointed for the personal PIRP asked me for some relevant information. And practically, there was no relevant information that I could give to them, which was not already in public domain. So, how much synergy and how much information do you think is common with respect to the process that RPs are required to take up in case, let's say, they're dealing with PIRP and they're also dealing with CIRP? I personally don't see too much of an exchange or interchange of information that can help the RP or bring in some synergies per se.
So earlier it was not allowed that the IP, who is the resolution professional of the corporate debtor, he was not allowed to become RP for the personal guarantors.
Yes.
And then the IBBI thought that the kind of synergy between these two is important, but there is no clash of interest. In both these cases, the RP is looking forward to the interest of the creditors. Therefore, if the same RP is appointed, that will actually assure better coordination. However,
So,
the RP of the corporate debtor and the RP of the PG does not have any kind of obligation to cooperate to each other. It is only a professional cooperation which actually can be sought. But I recently faced one difficulty because I was conducting the CIRP and somebody else was appointed as the uh, RP for the PG. So he was asking information from me, which probably I discussed with my legal team, and the legal team said that you cannot give information because of the confidentiality that you have to maintain. You cannot give the information to any other person who's been appointed as the PG RP. So therefore, I could not share any information because of the confidentiality undertaking, or the ethic code of ethics says that I will maintain the confidentiality. So there is no information which is getting exchanged between different RP for PG and the different RP for the corporate debtor. So therefore, there is no obligation also, and also there is a restriction that because of the confidentiality.
So I think very well answered. The possible synergy between these two processes can be the discussion with the creditors with respect to making a repayment plan or passing a resolution plan. Where the creditors looking into the PG process and looking into the CRP process can look at both together in case there is some synergy there. I think that's what I could get from that. With respect to information, these are two different entities, so the assets, the liabilities can be very different as well.
Yeah.
So then, a question from Sanchit ji. He says, in case there are 8 PGs to a CD and if OTS proposal is signed by one of the PGs, then will the limitation period extend for all the PGs to a CD?
I
I don't
don't
think
think the
so.
limitation period will actually get extended by just
Or,
OTS. One is the OTS given by the corporate debtor. That is the limitation period of the overall debt gets extended. But the separate OTS by one PG will not extend the limitation for the other co-grantor.
just one difference here. So in case the OTS proposal by one of the PGs is actually an OTS proposal in his capacity as the as some officer of the CD himself or the corporate himself, then it
Yes,
gets extended for all the
yes,
PGs.
yes,
But
yes.
if the OTS proposal is with respect to his personal guarantee only, then it doesn't extend the liability for all the other PGs. I think that would be the
That's also can be added. That's also can be added in the.
So then Harish G is asking how much maximum rate of interest can the bank demand from the PG? There is no limit. Whatever is written in the documents can be there. The normally the rate of interest that is asked or sought from the PG is based on the sanction letter, which is to the primary borrower. PG is only getting the liability amount from that amount.
Documented rate of interest and other charges is the amount that they can charge. And extortionate uh, credit transactions application of Section 50 is not extended to financial institutions and NBFCs. They can charge as much as they can.
So another question that in case let's say there are 8 PGs and the CDs in liquidation, then how will the liability of each of the PGs be fixed where total claims are 200 crores? So when there are 8 PGs and the total claims are 200 crores, the bank can officially, of course, say in case there is no limit on the personal guarantees, then they can actually say that okay, the total claims can be 200 crores from each of these 8 PGs, and that will, if they realize any money from any of the PGs, then they have to of course, remove that amount with respect to claim to the other PGs. So it is a joint and several liability, like in a partnership firm or like in other cases. You can't say that 200 crores will be divided by 8 and then it will be individual liabilities of all the PGs. That will not be the case here.
So the guarantee agreement is considered to be an independent agreement between the lender and the guarantor. It has got nothing to do with the co-guarantors. That is an independent agreement that I am giving 200 crore to the corporate debtor and you guarantee it, or he says, yes, I guarantee it. Similarly, all others says, yes, I guarantee it. So there is no question of dividing it into 8. How much, it's like in case the lenders recover from guarantor A, then the claim before the guarantor B or guarantor C will be reduced. But the bank can claim the entire amount from each of the 8 co-guarantors.
So Secured FC has filed application under Section 95 against the PG to the CD. Subsequently, PG has given resolution plan for the CD, being director for an MSME unit. Resolution plan is approved by COC and with the requisite majority, but applicant Secured FC has not voted in favor of the resolution plan. What will be the status of application under Section 95? So it will continue. I don't think if the primary borrower.
Let me answer this question, Ankit. One, that the lenders are trusting the same person to take over the company again by approving the resolution plan of that person. That means they still have the trust on that person who actually will be able to handle the business. Now, it is actually a contravention of the lenders filing an application under Section 95, because in case the repayment plan is not approved, then that particular person will actually go bankrupt. Bankruptcy application will be filed and that person will not be having any eligibility to continue with the business and also to become a director of a company. So therefore, the decision of the lenders, one, to approve a resolution plan of the same person and also initiate 95 against the same person is contradicting. Therefore, the lenders should avoid filing Section 95 applications against those people whom the company is given back under a trust. Now, the other option with the lenders is that they also should accept the repayment plan. Filing Section 9 application 95 is not bad, but they cannot go ahead and file bankruptcy. That means that they are this is not a kind of very wise decision, that we are first of all we are handing over a company to a person to run. In case that particular repayment plan is all payment is receiving upfront, then of course if the payment is received upfront, and then the banks can take any action against the personal guarantor to recover more. However, in case the resolution plan is having a kind of deferred repayment plan, then the decision of the bank may be contradictory. Yes, Ankit.
Right. Then we have a question which says that after discharge order in bankruptcy process, what are the restrictions on the bankrupt? Are there any restrictions on the bankrupt at all?
After the discharge order, which is mentioned in section, I think 140 and 141, there is no restriction on the personal guarantor or any individual. This discharge order is complete. This discharge order will not have and will not impose any restriction on the bankrupt who has come out of the bankruptcy process and the discharge has been given. However, one has to be very, very careful that in case any fraudulent activities are found against the personal guarantor, then the NCLT can restrict the discharge order. The NCLT can decline the discharge order. Then this particular scenario will continue for years till the time that fraud actions against the debtor is handled and that also positively in favor of the debtor. So therefore, the only risk towards getting the discharge is the finding of the fraudulent activities of the personal guarantor. Otherwise, the discharge is complete.
Right. Another question, interesting one, is Anju Chako. The question is whether demand notice under SARFAESI Act can be deemed to be invocation of guarantee. I don't think so. I think they're different documents. Can a demand order under SARFAESI, because these are always hypothecation deed, which is being used or which is being based on which SARFAESI action is happening, is different from the invocation of guarantee.
So there can be two demand notices under the SARFAESI law. One, the demand notice against the corporate debtor, against the company, the lender company, against the borrower company. Then there can be a second demand notice, which is for the personal guarantors. Now, in case any demand notice has been issued to the personal guarantors, even if it is under the SARFAESI Act, that would be considered the date of invocation of the guarantee. And that would actually trigger the limitation period. So, if there is any demand notice raised by the lenders to the personal guarantors invoking their personal guarantee, that will be considered as invocation of the guarantee and the limitation period starts from that date.
Right. Then we have a question from Shekhar Sriramji. She's saying that when the repayment plan is proposed based on sale of some properties, who will, whether the RP or the PG himself, sell the property and realize the money and make the payment as per the repayment plan? If the RP has to sell the property, what are the provisions?
Now, in the repayment plan, there will be a provision for monitoring the repayment plan process. In case there is any proposal to sell the property, there can be a monitoring committee which actually can have the RP and the debtor and the bankers. And then that monitoring committee will monitor the process of sale of the property. Individually, if the RP is allowed by the creditors that the RP will sell the property, that is also allowed. But it has to be a transparent process. If the RP is selling, it has to be a transparent process, and all these things will be mentioned in the repayment plan. Whether the property would be sold through an e-auction process, whether the property would be sold through a private treaty, that will be, or the mode of the sale of the property would be decided by the monitoring committee from time to time. That is the most important provision in the repayment plan.
Interesting question that if there are three PGs and three separate course assignments, three different RPs are working on these three different PGs, and there is a common banker, of course, and the repayment plans come in from each of these PGs, and the repayment plans are approved by the creditors. The total repayment plan, as per the submissions by the PGs, amount to more than the amount of debt. So can that be approved by the creditors, or will they have to put in a caveat that as soon as they realize the outstanding amounts, they will not realize more money from the PGs?
So practically this is not possible. The question, whatever the question is coming, this is not possible legally and practically. I think he is comparing the total debt of the corporate debtor. But as far as these three guarantors are concerned, the three guarantors are supposed to pay the debt as per the notice of demand plus interest. That is the amount that they have to pay. And nobody can give a repayment plan which is more than the amount of the claim.
But the
Nobody
claim
can
is
give a
multiplied
repayment
by
plan.
claim is multiplied by 3, no? So in case, let's say there's 100 rupees outstanding from the CD, and each of the PGs also effectively have 100 rupees due against them. Let's say PG 1, 2, and 3 all, for simplicity purposes, gives plan value of, or give a repayment plan for 75 each. So in that case, the bank will get more than 100, which it cannot get. That's the question.
As I said, when the first repayment plan is approved, that will reduce the claim of the other two guarantors. When the second repayment plan is approved, that will reduce the obligation of the third guarantor. So this is not possible at all as per
That
law.
the moment repayment plan is approved for one of the PGs, the answer is that moment one PG's resolution repayment plan is approved, automatically the liability against the other two PGs reduces,
Reduces.
irrespective of the repayment plan getting get realizing actual money after 1 year, 2 years, or whatever is proposed.
No, no. Like, see, like if it is possible, then I think then the NCLT will take care of this. NCLT will pass the order while approving the repayment plan that in case the amount is recovered in the any of these three repayment plan, then the amount recoverable in the other two repayment plan will be reduced accordingly. So
So
that
the
kind of
bank
order will
can
be
the
passed
bank
by
can
the
also
NCLT.
approve. So the bank can also put that clause in the repayment plan itself.
Absolutely.
The NCLT can also put that stipulation here. So that would be the control mechanism to make sure that the bank doesn't get more than what it has dues of.
Right.
Then, if creditor recovered from one PG, then can the said PG recover the proportionate amount from the other PG in the said case, said
Oh.
CD?
No, there is
I
no
don't.
right of subrogation on the co-guarantors. There is no
The
possibility
subrogation
of
is only on the principal borrower.
that is also denied by Lalit Kumar Jain on the corporate debtor. Lalit
Hmm.
Kumar Jain order of Supreme Court dated 21st of May 2023 says very clearly that there is no right of subrogation on the corporate debtor.
If the corporate debt is under insolvency, if the
If the
corporate debt is
corporate
not
debtor is
under
under
insolvency,
insolvency,
but if the corporate debt is not under insolvency, the subrogation will continue.
that subrogation will continue.
Then, in notice under section 13(2), the demand is made from the CD as well as PG without special mentioning about the invocation of guarantee. Whether the said notice will be treated as invocation, I think we've already talked about this.
Yes, because the notice which is issued to the grantor, that means that the guarantee is invoked. Otherwise, no banker can give notice to the directors for recovery of that amount given to the corporate debtor.
In PG case, can a claim received after the last date of claim submission be submitted by the RP, admitted by the RP?
It all
How will
depends whether the repayment plan is received or not. If the repayment plan is received, I still feel that because in this insolvency resolution process of personal guarantors, only those claims are discharged who have filed their claim and is the process of insolvency resolution in the also have taken participation in the IRP process. So not all the claims are discharged. In case, but yes, the claim filing process is something which is not defined whether the claim can be admitted by the RP, belated claim can be admitted by the RP, or the person will go to NCLT for getting waiver of the delay. So, but there are possibilities in the insolvency resolution process that the discharge given to the insolvency, given to the PG is also limited, not very, very vast. However, the discharge under the bankruptcy process is complete from all respects.
Then there are three good questions. So one is that application is filed under section 94, but the PG is not in possession of the document of guarantee deed executed on behalf of the CD. So will this be a problem for the 94 application to be taken up by the adjudicating authority, DRT or NCLT, if this document of guarantee is not available with the PG, but he knows that I've given a guarantee?
Yes, it is a difficulty because the recently this Ahmedabad court has rejected a case where the documents were not filed, it was not available, and the finally after about 2 years time, the application was dismissed because this was not fully documented. So the deed of guarantee, the proof of invocation of the guarantee, and the default. Three things are very, very important. One, that there was a guarantee document, and the two, there was an invocation of the guarantee. Three, that the debtor, the personal guarantor could not make payment. So these are the three evidences which are must for filing an application under section 94 or 95. So in case this is not available, filing is possible, but getting admitted is not possible because most of the people are filing the application under section 94 just to get the benefit of section 96 moratorium. That was available. The moratorium was available, but after hearings of 2 years, after getting all those documents from the banks, then the court said that you have submitted these documents without our approval, without our permission. That is also not permitted. The court did not permit to submit, did not permit the applicant under section 94 to submit the documents, and that too after 2 years, and that too without the permission of the court. So those documents were not taken on record and the application was dismissed. However, in case somebody has to do this, the application can be submitted to get the benefit of section 96. Again, the documents can be submitted later on by taking permission of the court. Yes.
Then another question that is there any requirements to maintain or open a bank account during the PG resolution process? I
No,
don't think so.
there is no requirement because see, the RP is not responsible to take control and custody of any asset. There is no requirement of opening a bank account or taking any control on the existing bank accounts of the guarantor.
Hira Chandji is asking that what is the time limit to file reply of 99 report?
10 days.
Up to court.
No, reply. The reply to be filed by the personal guarantor, and that is the whatever the court allows. Because this reply has to be filed before NCLT or any court. So whatever court permits, that is the time for filing the reply.
In case the liability of CD is agreed to be paid by the PG under the IBC process, can other OCs file petition under Section 9 against the said CD during repayment of loan period by PG? So PG, when it is repaying the loan, it is repaying the loan or repaying the payment with respect to that entity or that creditor which had taken the PG's guarantee. Now, in case you talk about operational creditors, understanding or assuming that the operational creditors had no personal guarantee from the personal guarantors, they still have a claim against the CD, which is a valid claim. So they can always file a petition under Section 9 against the CD in case their dues are not realized.
So Ankit, in case there is no insolvency for this corporate debtor and the personal guarantor is making payment of the loan of the corporate debtor, that means that he is making payment of the loan without any moratorium of Section 14. So if there is no moratorium under Section 14, any OC can file an application under Section 9.
Right. Then I think we have taken care of some fee-related questions. And with respect to what should be the fee range of the RP till repayment plan in PG, and those questions are there. And then what will be the fees of the RP starting from the appointment under Section 95 or Section 100? So then there's a question which is IP1 required to be filed to IBBI on appointment by NCLT. So I think that's a question. So that's what I
I
think we
think
have taken.
regarding fee, in fact, in the last episode 128 also, I explained that the banks are negotiating too hard with the insolvency professionals for personal guarantor matters because the fee is likely to be paid by the applicant in case there is no repayment plan. So in case if there is a repayment plan, then the insolvency resolution process cost will be borne by the resolution applicant and in the resolution plan, in the repayment plan. Now, the applicant is trying to save their cost and they are arguing multiple things. One, that the fee will start from the date of the order under section 100. However, the RP obligation starts while actually section 97 while 96 order comes. Then the RP is supposed to give a report, interim report under section 99, and that is also time consuming. Then the RP is also attending all those court hearings where others are actually filing objections against the section 99 report. Then in the insolvency resolution process of PG, within 120 days, the repayment plan has to be submitted or a report has to be submitted that no repayment plan has been received or approved by the committee, a list of the creditors. Then thereafter, the RP has to hear the court, attend to the court hearings and also to brief the lawyers. So to my understanding, the fee, one, there should be a separate fee for preparing and attending to the hearings for section 99 report. Then from the commencement of the insolvency process under section 100, it should end for 180 days. And in case the NCLT takes longer period, then some additional fee for that period, because for every hearing, the RP will have to be present in the court or will have to brief the lawyer. So the work actually is much more than the fee what is being offered presently. So therefore, all the insolvency professionals should be very careful in accepting the PG assignments, because it might give you experience, but it will not give you any remuneration.
So I think we have answered many questions. And last question, that does RP need to file IP1 for filing report under section 99 also?
So I don't think IP1 is only when the consent is given. This is what I understand. My team handles all these IBC compliances. But yes, I think this is when the NCLT gives you appointment, then that particular document or form, which is IP1, when you give a consent, that may be not required. But I definitely have to verify the regulations specifically for this. And then, yes,
please go on.
I just wanted to say that I just wanted to say, like, there are many judgments which say that once a person is deceased, no insolvency process can be started against the guarantor. Then again, although there are 2-3 judgments regarding this, but then section 169 and 170 of the IBC very clearly say that the bankruptcy process can be started against the legal heirs. So I think this particular 2 sections are getting ignored by the professionals. So they are not specifically arguing that the very, very specific sections 169 and 170 of the IBC says that the action can be started against the legal heirs, even if the resolution process may not be, but then the bankruptcy can be started against the legal heirs of the deceased. Then there is a judgment which is in our case. Yes, Ankit?
Especially in case there is some asset which was belonging to the personal guarantor, which has now been transferred to the legal heirs. Legal heirs will, of course, can be implicated, but will it not be restricted to the value or property which has passed on to the legal heirs from the original guarantors?
Absolutely. It is only restricted to the inheritance, not to their own earned assets. It is only
so the RP who is appointed. So the RP who is appointed for a PIRP of a legal heir will have to restrict his repayment and restrict his process or restrict his report to the assets which were belonging to the original guarantor and which are now belonging to the legal heir.
Yes, absolutely right. So there is another case which is decided by the NCLAT on 29th of July 2022. That's in our case, Sudeep Bijoy Datta versus State Bank of India. In this case, the Sudeep Datta, in fact, was arguing that he has taken the citizenship of Singapore. He is no more a citizen of India, so the personal guarantor applications cannot be started. NCLAT held that it is nothing like the The personal guarantee.
Citizenship has nothing to do.
Residential status has nothing to do. Then the other thing that I would like to say, that I in fact prepared some of the questions from my side. Can the resolution professional be replaced? And who has the authority to appoint a new RP? Yes, the RP can be replaced. Section 98 of the IBC provides that either the debtor, the personal guarantor, or the creditor can apply to the adjudicating authority to replace the RP. The adjudicating authority will then appoint a new RP from the panel provided by the Insolvency and Bankruptcy Board of India, and neither the creditor nor the debtor has a right to propose a new RP. Even if there is a power to change, but no one, neither the debtor or the creditor, has the power to propose the new RP. The replacement needed, if they require a replacement, that is also replacement can be done only for monitoring the repayment plan, and that also with 75% of the voting of the creditors can be done. Otherwise, that also cannot be done. Now, the other thing that I can actually say, who can file the application for bankruptcy? But I'm saying the bankruptcy process is not automatic. The bankruptcy application can be filed by either the personal guarantor or by the creditor according to section 121 of the IBC. The bankruptcy process can be initiated if the repayment plan fails or if the insolvency resolution process does not lead to a satisfactory outcome. The creditors or the personal guarantor can file an application directly under section 95 subsection 1 and or section 94 section the personal guarantor if the repayment plan is not approved. That's what is the application. So there are a lot of documents which are required to be given. I think, Ankit, because of the time, I have in fact a lot of ammunition, but the time is always a scarcity, and we would like to just keep the attention of our. So I think this is we tried to answer most of the questions according to our own understanding of the law relating to personal guarantors. There are many other questions that we have in mind, but we gave the preference to the audience questions. So this is our way of learning. In case of any further discussions required, you can reach out to us on that email which is given in the description when we upload this webinar on the YouTube. So thank you very much. This is our way of learning, and thank you very much in having this interactive session.
Thank you, everyone.